Hello everyone, I am Manvendra Kumar Tiwari, Assistant Professor, Dr. Ram Manohar Lohia, National Law University, Lucknow, and today I am going to talk about preventive detention. Now, as it is clear from the name itself, this is preventive detention, and therefore, the learning outcome in relation to this module on preventive detention must be able to make the readers understand the need for preventive detention, how preventive detention is different from punitive detention, and the fine balance which our constitution, that is the Constitution of India, tries to strike between personal liberty and the needs of societal peace and security. And finally, the module will also be able to make the readers understand the judicial trends when it comes to the interpretation of issues emanating from the issue of preventive detention. Now, coming to the meaning of preventive detention, as it is clear from the name itself, this is preventive detention, meaning thereby with a view to prevent a person, and what is the consequence? That a person is detained. So, it means the physical detention of a person with a view to prevent him from doing an act which is undesirable or which poses a threat. Now, what kind of acts may be termed undesirable, and what kind of threat the act may pose for the state to intervene and take away someone's personal liberty in the pretext of it being a preventive detention. Now, in order to find this, one has to look into what is actually provided in Schedule 7 of the Indian Constitution in Union list and in concurrent list, because preventive detention is a topic which finds mention in both Union list and in concurrent list, meaning thereby both the center as well as the state governments are competent to enact laws in relation to preventive detention. And there itself in 7th schedule, in these two lists, several heads are given for the protection of which legislation can be enacted with a view to ensure societal peace and security, and thereby depriving a person of his liberty. Now, what these heads are? Now, these heads includes defense of India, foreign affairs, security of India, security of state, maintenance of public order, maintenance of supplies and services essential to the community. As I said, these find mention in list 1 and list 3, that is Union list and concurrent list of the 7th schedule of the Indian Constitution in relation to the power of the respective center and the state government to enact laws in relation to preventive detention. Now, coming to the distinction between preventive detention and punitive detention. Now, as I said, preventive detention is detention apprehending the commission of an act, whereas punitive detention is detention pursuant to the commission of an act. Secondly, in preventive detention, detention is with a view to prevent the commission of the act, whereas in cases of punitive detention, the detention is part of the process to fix the liability of the culprit for the offense that has been committed. Thirdly, in cases of preventive detention, there is no trial. So, in fact, the another name for preventive detention is detention without trial, whereas when it comes to punitive detention, the detention very often precedes trial until and unless no prima facie case have been found against the person who has been arrested so as to start prosecution. Preventive detention under the Indian Constitution. In the Indian Constitution, Article 22, which is there in the chapter of fundamental rights, deals with the issue of preventive detention in great detail. If one examines the provision, that is provision of Article 22 in relation to the issue of preventive detention, one would find the obvious dilemma that the framers of the Indian Constitution had in ensuring that the personal liberty of an individual is not unnecessarily compromised, and at the same time trying to strike a fine balance between the issue of personal liberty and ensuring the issue of societal peace and security. It has been very reluctantly accepted even by the framers of the Indian Constitution as an inevitable measure, and therefore they have tried to provide safeguards in the Constitution itself. As has been said on many occasions, preventive detention is a necessary evil, but the fact is that it is essentially an evil, because by this a government authority is empowered to detain a person on mere apprehension of he having he in future may be involved in activities which are undesirable and which pose a threat. Now, what is there in Article 22 mainly? Now, if you look at Article 22 of the Indian Constitution, one would find that it starts with an example wherein a person has been arrested in pursuance of the commission of a crime, and therefore it says that in such cases the person has to be presented before a magistrate if at all the detention has to continue beyond 24 hours. But when it comes to preventive detention, it says that this provision is not applicable when it comes to preventive detention, meaning thereby a person can even be detained for a period more than 24 hours without seeking an authorization from the magistrate. In fact, Article 22 clarifies that a person can be detained under preventive detention for a period up to 3 months only in case the detention has to exceed the period of 3 months that an authorization from an advisory board is necessary, and the advisory board must be comprised of a person who is or has been or somebody who possesses the eligibility to be the High Court judge, meaning thereby if a person is to be detained beyond a period of 3 months, then the authorization of an advisory board which is to be constituted under the law dealing with preventive detention is necessary. But in the same Article 22, it is also provided that the Parliament may by law provide that in certain cases the authorization of the advisory board so as to prolong the preventive detention beyond a period of 3 months may not be necessary if the law so provides. At the same time, Article 22 also says that the extension of preventive detention beyond the period of 3 months must not be beyond the maximum period of preventive detention that is provided under the law made by the Parliament. Now, what is there for the protection of the detenu? Detenu is the person who is detained preventively. Now, when it comes to Article 22, the main safeguards which are provided to such persons, apart from the safeguard that the detention can only be for a period beyond 3 months under the express authorization of an advisory board, are the first one, the communication of the grounds for detention. Communication of the grounds for detention, that is, the person detaining the detenu must tell him the grounds on the basis of which the detention order has been passed, pursuant to which he has been preventively detained. And secondly, making an opportunity, providing in fact an opportunity to make an early representation against the order to the detenu. Now, why these two powers, why these two safeguards are there? Because it is only legitimate that a person who is being preventively detained must be informed of the reasons for his detention, and secondly, if he is not in agreement with the reasons that are provided for his detention, he must be given an opportunity to represent his point of view. Now, coming to some of the legislations, as I said, the power to enact legislations dealing with preventive detention is provided for in the list 1 and list 3, that is Union list and concurrent list of the 7th schedule of the Constitution of India, whereby both the state as well as the union government is empowered to enact laws on this issue. I will only be giving some illustrative examples of some of the examples of the examples of the legislations enacted at the level of center. Firstly, even before the commencement of our constitution, the concept of preventive detention was not an alien concept. In fact, the Bengal Regulation 3 of 1888 provided for a measure of preventive detention, and even the Rule 26 of the Defence of India Rules 1939 provided for preventive detention. After the commencement of the constitution, we had also some examples of preventive detention legislations like Preventive Detention Act 1950, Maintenance of Internal Security Act 1971, and Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974, also called COFE POSA, and National Security Act 1980, and Prevention of Black Marketing and Maintenance of Essential Commodities Act 1980. These are only some of the illustrative examples of the various enactments providing for the issue of preventive detention, not mentioning several other state legislations on the same issue. Now, coming to the judicial interventions, as I said, Article 22 provides for various safeguards to the person who is to be preventively detained, and therefore those safeguards will be enforceable at the behest of the courts, and mainly the High Court and the Supreme Court, and a study of the judicial interventions would make us understand better as to what has actually been the contours of this protection that is accorded to the individuals by our constitution. Now, starting with a very old case of A.K. Gopalan versus State of Madras. This is a 1950 Supreme Court judgment. Now, in this case, a very important, a very significant argument was raised by the petitioner, whereby he said that when a person is preventively detained, apart from his personal liberty, his other freedoms as guaranteed under Article 19(1) are also taken away from him, and therefore an order of preventive detention, apart from fulfilling the requirements as given under Article 22, must also comply with the requirements which are expressly enumerated by our constitution in Article 19(2) to 19(6), meaning thereby only if the reasonable restrictions as provided under Article 19(2) to 6 for a legislation to deprive a person of the fundamental freedoms as guaranteed under Article 19(1) are provided, that a person can actually be deprived of his liberty in pursuance of Article 22, meaning thereby the petitioner wanted that the reading of mutual exclusivity vis-a-vis different provisions of fundamental right ought to be forsaken, and a more meaningful reading of the fundamental right should be undertaken. That is, if personal liberty has got a bearing on some other fundamental rights guaranteed to a person, then in that case only fulfilling the conditions prescribed under Article 22 would not suffice. The order depriving a person of the liberty must therefore also account for the reasons subject to which only a person can be deprived of those fundamental freedom, which are obviously always compromised when a person is detained preventively. Now, in this case, Supreme Court refused to accept this argument, and in fact said that the fundamental rights as enumerated in Part 3 of the Indian Constitution are to be read mutually exclusively, meaning thereby if personal liberty under Article 22 is different from the fundamental freedoms under Article 19, and therefore so long as the attributes of Article 22 are fulfilled, the same the executive exercise of ordering preventive detention ought not to be tested on the touchstone of Article 19(2) to 6. Another very significant judicial intervention, or should I say non-intervention, is the case of Additional District Magistrate Jabalpur versus Shivakant Shukla. This is 1976 Supreme Court judgment. Now, in this case, the issue before the Supreme Court was as to whether a person can challenge preventive detention of his on the grounds that the law under which his freedom has been taken away from him has actually not been complied with, and the fact that the exercise of the executive discretion in ordering preventive detention is actually marred with the vice of arbitrariness and malafide. Now, another very important aspect related to this judgment of the Supreme Court is that this was passed, this judgment was delivered by the Supreme Court during the period of emergency, which was proclaimed by the President under the exercise of his powers under Article 352 of the Constitution of India, and pursuant to the proclamation of emergency under Article 352, even an order was issued under Article 359, whereby all fundamental rights as provided in Article 359 of the Constitution were suspended during the period of emergency, and this was a period of emergency, and the persons who have been preventively taken into custody, they in fact have challenged the basis of they having been so taken into custody by questioning that their detention is not in sync with the very legislation under which they have been preventively detained. The legislation in question was the Maintenance of Internal Security Act 1971. Now, this issue in fact came to the Supreme Court from the 7 different orders of the different high courts, whereby they have all accepted, all 7 high courts in its order have accepted the argument of the petitioner, and they have finally decided that the executive order of preventive detention is actually not in sync with the requirements of Maintenance of Internal Security Act, and therefore are invalid. But the Supreme Court in this case took a stand very different from the stand that was taken by the High Court, and concluded that since during the time of emergency all fundamental rights are suspended, therefore a person has got no right to approach the court challenging the basis of the order on the ground that the requirements of as provided by the legislation for the passing of the preventive detention has not been complied with, or the fact that the orders are actually vitiated because it having been taken in a manner which is completely malafide. This is a very debatable and a much criticized judgment of the Supreme Court, and many commentators even today point out this to be a case of absolute surrender of the Supreme Court to an absolutist government. Finally, in Maneka Gandhi versus Union of India, this is 1978 judgment of the Supreme Court. The Supreme Court in a way tried to undo what the previous 2 decisions of the Supreme Court have actually done. In fact, even before the Maneka Gandhi judgment of the 1978, the 44th constitutional amendment of the Constitution has tried to undo to a great extent what was not done by the Supreme Court in ADM Jabalpur versus Shivkant Shukla case. By this, Article 359 of the Constitution of India was amended, and it was provided that even during the times of emergency, an order suspending the fundamental rights of the citizens cannot suspend the fundamental rights flowing from Article 20 and 21 of the Constitution of India. Now, coming to the issue that was undertaken in the case of Maneka Gandhi versus Union of India. Now, in this case, the theory of mutual exclusivity as propounded by the Supreme Court in A.K. Gopalan versus State of Madras was rejected by the Supreme Court, and the Supreme Court concluded that infraction of personal liberty would have a direct bearing upon all those articles within the fundamental right chapter providing for the various aspects of personal liberty, and therefore a legislation which is meant to preventively detain a person must also pass the test of its validity as provided in other provisions of fundamental right as well, meaning thereby because of this interpretation of the Supreme Court, a legislation under Article 22, that is a legislation providing for preventive detention, can even be challenged on the ground that it is inconsistent with the grounds as mentioned in the Constitution of India under Article 19(2) to to 6. Another very important aspect of the judgment of the Supreme Court was that the Supreme Court in this case said that the procedure subject to which a person is entitled to enjoy his personal liberty and life under Article 21, that procedure has to be a just, fair and reasonable procedure, and it cannot be any legislative procedure. Now, this further cushions against the excesses that may be committed by the executive in its exercise of order of preventive detention, which it is entitled to pass under various legislations. Now, coming to the issue of judicial review of detention order, as I said that the two specific safeguards which are provided for in the Constitution, specifically in Article 22, the first one is that the person must be informed of the reasons of the detention. Now, how has the Supreme Court read this requirement of Article 22? Now, the Supreme Court in various judgments has said that when it comes to a challenge of the grounds for the passing of an order of preventive detention, what the court has to look into as to whether the reasons as communicated to the petitioner are misconceived, irrelevant and non-existent or not. The fact that in an individual's assessment the reasons as provided may not be sufficient to come to a conclusion to pass an order of preventive detention is something which the court should not go into, meaning thereby the court in a challenge on in a challenge related to the communication of orders to the petitioner should not go into the sufficiency of the reasons for the executive officer to have come to a conclusion to pass an order of preventive detention. Rather, the court must only be concerned about the fact whether the reasons are actually existent, whether the reasons are actually relevant, and whether the reasons are misconceived or not, and only if it finds the reasons to be so that the court should intervene and quash such orders of detention. But when it comes to following the procedures as prescribed for preventive detention, the court has been very firm, and on many occasions the court led by the Supreme Court has said that any kind of deviation from the procedure when it comes to an order of preventive detention is not to be tolerated, because what in question in these cases is an individual's liberty, and it cannot be so easily traded that you would condone those procedural irregularities. Now, when it comes to judicially examining the reasons as provided by the executive for its order of preventive detention, what the court must look into is as to whether there is a rational nexus between the preventive detention order passed and the reasons accorded for passing of such order of preventive detention. And if that exists, then in that case the court would not intervene and quash the detention order. And this has been stated by the Supreme Court in several cases, like Shafiq Ahmed versus District Magistrate Meerut 1989, State of Punjab versus Sukhpal Singh 1990, and Pebam Ningol Mikoi Devi versus State of Manipur. This is 2010. In fact, the Pebam Nicole Mikoi Devi versus State of Manipur is a case wherein one of the reasons which was given by the executive authority as a ground for preventive detention was a statement made by the petitioner to the police under section 161 CRPC. Now, the court in this case took this to be a reason which is entirely misconceived and irrelevant and non-existent, as the statement given under section 161 of the Code of Criminal Procedure to the police officer has got no evidential value except to contradict prosecution witness in the prosecution, and therefore the court came to the conclusion that the reason accorded is entirely misconceived and quashed the order of preventive detention. Another very important aspect related to an order of preventive detention is as to whether it is necessary for the executive authority issuing such orders to have first examined as to whether there is a scope for launching a criminal case against the petitioner. Now, the Supreme Court in State of Punjab versus Sukhpal Singh, which is a 1990 Supreme Court case, said that this though is a very relevant factor, but it is not so conclusive so as to completely vitiate the detention order. That is, if this has not been considered by the executive authority, this is a relevant fact in coming to a conclusion as to whether the executive authority was careful or not in passing such an order, but this should automatically not vitiate the very order of preventive detention. Another very contentious issue related to the reasons accorded for the order of preventive detention is actually related to those cases wherein the executive authority in fact accords multiple reasons for the passing of the order of preventive detention, and it is found that one or two out of the multiple reasons accorded for the preventive detention order are actually non-existent, irrelevant or entirely misconceived. What the court should do then? Now, the fact that the court has reiterated in many cases that the insistence on procedure is a very strict requirement, because what is at stake is the personal liberty of an individual. The court has accordingly held in several cases that in such cases the entire executive order of preventive detention is to be quashed, even if one out of this multiple reasons accorded is found to be irrelevant, irrelevant or misconceived. Now, this has created considerable turbulence, especially from the point of view of executive authorities, and keeping in mind this, even the legislature in India has tried to alter the laws, and one such specific example is section 5A of the Coffey-Posa Act. Now, in this, what has been provided? Now, this section specifically says that in case one or more of the reasons given for passing of the order of preventive detention has been found to be misconceived or irrelevant, then in that case, every reason that is given for the passing of the order of preventive detention must be deemed to be sufficient to constitute a case of preventive detention. Now, what is unique in this provision is that this provides for a deeming clause, whereby regardless of the fact that the multiple reasons have been given by the executive authority in order to pass the order of preventive detention, all those reasons in itself are deemed to be sufficient to constitute a case of preventive detention. Now, this is specifically enacted so as to undo what the courts have been doing in cases wherein out of the multiple reasons given, even if one of the reasons given are found to be irrelevant or misconceived. Now, the question therefore arises is, should this be acceptable? Should this be considered to be a case of legislative overreach? Now, this was challenged in this very provision was challenged before the courts, but contemplating the judicial scrutiny of this provision, the Parliament of India has gone ahead and put this legislation in 9th schedule by way of 39th constitutional amendment, making it immune from judicial review. Nevertheless, this issue was undertaken by the Supreme Court in Attorney General for India versus Amrit Lal Prajivan Das in the year 1994, and the Supreme Court concluded that section 5A of Coffey-Posa is actually constitutional, because the legislation has been put in 9th schedule and the provision actually provides for a deeming clause. Now, in the present context, if we read this judgment, we may have reservations with this judgment, because in the year 2007 the Supreme Court in I.R. Coelho versus State of Tamil Nadu has categorically stated that a legislation put in 9th schedule is not immune from judicial scrutiny only because of the fact that it is put in 9th schedule. And therefore, this raises very pertinent question. In fact, if we go back in the year 1972 in Yadav Reddy versus State of Andhra Pradesh, the Andhra Pradesh High Court has declared a very similar provision in the Andhra Pradesh Preventive Detention Act 1970 unconstitutional, being violative of Article 22(5) and Article 19(1)(d). 19(1)(d) deals with the right of a person to travel within India. Now, what was provided in this very law? Now, in section 6A of this law said that no detention shall be invalid or inoperative merely by reason that one or more of the grounds on which the order is made is or are vague or irrelevant. What it has not provided for is that deeming clause which was provided in the Coffey-Posa Act, but the effect of this very provision and section 5A of the Coffey-Posa Act is exactly the same. This was declared in the year 1972 unconstitutional, but we have that provision in Coffey-Posa Act is still continuing as constitutional. Now, coming to the second aspect of the right of the detenu, which is the detenu's right to make representation. Now, in this case, the courts have clarified that the communication of detention required by Article 22 must be in the language and the script that the detenu can understand. Now, this is very, very important, because the person who has been preventively detained must be able to understand the grounds, and for that to happen, it must be given in the language and the script that he is able to understand. And this has been stated by the Supreme Court in the cases of Hari Kishan versus State of Maharashtra, which is a 1962 Supreme Court verdict, and Harbandhu Das versus District Magistrate Cuttack, which is a 1969 Supreme Court verdict. The representation made must also be disposed of very expeditiously. In State of Punjab versus Sukhpal Singh, a delay beyond 15 days was not accepted by the Supreme Court as the time which is which executive authorities can ordinarily take in order to dispose of a petition, and they said that this amounts to violation of the right given to the person, and therefore quashed the very order of preventive detention. Now, finally, after discussing all the contours of the issue of preventive detention, summary of what we discussed today. The existence of the concept of preventive detention in a democracy aptly describes the dilemma of a state wedded to the axiom of rule of law, wherein it has to ensure a fine balance between the protection of individuals' liberty and the societal need of ensuring peace and security and maintaining free flow of essential commodities. This is necessary evil because the orders of preventive detention are to be passed by the executive authorities, and therefore there is always a scope of for the same being actually marred from the vice of arbitrariness. In order to ensure that the preventive detention powers are not misused, Article 22 of the Constitution has tried to provide for various safeguards. The safeguards include the immediate communication of the grounds of detention and the expeditious disposal of the representation, which is again mandated by Article 22 to be enabled to the detenu so that he can make an effective representation against the grounds of detention, and the same must be expeditiously disposed of. Apart from this, if the detention has to continue for a period longer than 3 months, then Article 22 again provides for the fact that it can only be done if it has been authorized by an advisory board. This requirement can only be dispensed with by a specific law provided by the Parliament, and that too enumerating the specific circumstances in which this can actually be done. Apart from this, even in cases wherein the preventive detention can exceed a period of more than 3 months, Article 22 provides that it cannot exceed the maximum period as provided by law by the Parliament for the purposes of preventive detention. Now, these are some of the safeguards as provided in the Constitution by specifically providing it in Article 22. The various judicial interpretation of the safeguards further add to these safeguards as provided in the Constitution and in various laws. And even from reading of the judicial trends related to the issue of preventive detention would aptly convey the fact that the Supreme Court has been very, very strict when it comes to the issue of preventive detention, and it has not tolerated in most of the occasions even slightest procedural deviations, and barring few unwarranted departures, the Supreme Court generally has been very, very firm in ensuring that the individual liberty as guaranteed by the Constitution of India must not be sacrificed at the altar of executive expediency. Thank you very much for your time. Goodbye.